Two quick questions. One, you used the word intentional when you said that John Lindh was prohibited from saying that the FBI had used intentional da-da-da-da-da. So my first question is, could he say that they accidentally? I mean, is that a semantics thing? And the second question is, what are the consequences if you or someone else at your level of whistleblowing, or not whistleblowing actually, but if you disobey the gag orders, what are the consequences that have been laid out to you?
That you can be put in jail. Which I mean, I applaud journalists who are willing to test that. I have 3 young kids right now, and I can't. There's some. I've already spent hundreds of thousands of dollars trying to combat this, and I'm willing to talk about it up to a certain point. But again, right now, have they struck the fear of God in me? Yes, because of all the petty things they're willing to do. I take it very seriously when they say, don't talk about certain things. In terms of that language, where Lindh had to swear that he had not been intentionally mistreated, I think that is a tacit admission by the government that he was mistreated. And by putting in, not intentionally, they were basically bulletproofing themselves from, they also made him state outright that he would never bring a future claim based on torture, but they were insulating themselves and bulletproofing themselves from a lawsuit later on for Eighth Amendment cruel and unusual violations.
I got up to ask you a few minutes ago about the state secrets privilege, and while I was walking over to the mic, you answered the question, but I'm still not satisfied that I understand what's going on here, because it seems to me that by invoking the state's secret privilege, the government is pulling out a club that it can use to knock down anything whatsoever, and this club has no existence within either our legal history, our legal traditions, our constitution, our constitutional jurisprudence, or anywhere else. So what I'm wondering, I'm really quite puzzled why any judge would allow a federal lawyer to walk into a courtroom and invoke the state's secret privilege. Why doesn't he say, get the hell out of this court and come back when you know the law?
Some judges have. There have been a handful of judges who have done that. Louis Fisher, who works for the Congressional Research Service, is the state secrets expert. He has an article in the Harvard Journal of Law and Legislation going over exactly what it is, how it can be asserted, where it came from, which was this really screwed up case called Reynolds back in circa 1950, again, where state secrets was asserted about something that was not really a secret at all. Some judges have said no to the government when they've said, oh, this person can't testify because he's an enemy combatant and he will reveal important information. Well, there are procedures set up to handle that in court. We have CIPA, we have the Classified Intelligence Protection Act, we have things set up to hear that. So when they're like, no, we need to create military tribunals where we're going to have the same people be the judge, jury, executioner, and defense attorney, and we can't have these people in real court, we can. Some judges have begun to say no or to challenge the government, and other judges who've been very happy about it, to embrace the state secrets privilege, have been recently elevated to the Supreme Court.
Well, I appreciate your answer, but I'm just compelled to say that this is utterly Stalinistic, and that if the Americans tolerate this kind of behavior from their courts, these courts have lost all credibility whatsoever.
Yep.
one last question.
Okay, this is the last question. I'm getting the 15 minutes, 5 minutes.
I
1
appreciate Robert Hicks's question. I hope
agree.
that this might be of interest to you, as I've been involved with these things for a long time. There's been a lot of talk over the years, you know, with the collaboration of the British, who have the Official Secrets Act, that we have to get something comparably here, you know, in the restructuring and the reality of national security. And there's a lot going on about that for a long time. So I think you with your abilities and research ought to look into that. I could tell you more offline. The second thing, I mean, about the Official Secrets Act that the British have, and you know they're much more tight on that. Connected with this too, and as I've told a couple of other colleagues here, one of the things I learned only in 1995, having been involved in some pretty sensitive things, is that not only does the intelligence community or the secrets protect sources and methods, but liaison. Remember that word, liaison. And I assure you that certain other countries that we collaborate with have control over what's releasable. We do not have control, and including even things that are older than 50 years. And I could give details to some of you offline. And I think this is a very important matter. You hear about protection of sources and methods, but also liaison, foreign liaison, and you can understand some of them say, well, if I'm going to give you things, and then you're like Swiss cheese, you know, you're not going to do it. So it's a complicated matter. But the question I asked for you, ma'am, just briefly, I don't want to get you into more trouble, but maybe you could at least give the history. And if this that gets you into trouble, please don't say anything. But I think of the precedents in the Office of Special Investigation, OSI. Some of my friends that were very much involved a long time ago at senior level that I've known since I was a little boy said to me, someday I might be able to tell you about this. I mean, it's that serious. Now, I knew that they used evidence of foreign intelligence communities in order to prosecute, but I'm just wondering if the permanent bureaucracy in justice, that there's still lingering things or restructurings, even if the OSI is no longer formally there. Someone told me it might not be actually there on the chart, but would you care to comment at least on the history of this, OSI? Or
I wish I knew more, I mean, about the history of OSI. And again, I talked to people like Louis Fisher to try to find out more about the history of the state secrets privilege. And
it's Office of Special Investigation.
Yeah.
I don't know. I'm sorry, I don't think I said that.
That's fine. Office of Special Investigation. The problem is, I don't doubt that there is reason to keep certain stuff undercover and keep certain stuff secret, but every single document these days is being classified. Things are being overclassified, state secrets privileges being applied to everything, and meanwhile, the things that should be secret, like CIA agent identities who are undercover, are being exposed. So, you know, I don't doubt that there is stuff that validly should be classified or that might validly be subject to some sort of state secret privilege or high-level classification and that kind of thing. But when you're classifying ordinary citizens, when you're putting them on terrorist watch lists, yeah, I'm a mother of 3. I'm like 100 pounds soaking wet. I'm not a terrorist. I mean, it's a big waste of the taxpayer dollar to be doing that. And, you know, a lot of people are gagged indefinitely. We don't even have the 70-year rule. So maybe when I'm, you know, 99 or 100 or whatever, I can talk about certain things, unless someone new comes in and unties the knot of the gag. But my time has expired. I'd be glad to talk to people later. I'll be floating around, so buttonhole me.